Good morning, everyone. And this is a very timely topic for companies, corporations, entities that are engaged in any sort of construction work. So we're going to be talking about amendments to the Construction Lien Act. And as an outline, we're going to cover some of the background and how we got to where we are now. The amendments to the prompt payment amendments, which are new provisions in the Act that are being introduced. Interim Adjudication amendments, which are also new provisions. Some other miscellaneous amendments that impact provisions that are already in the current Construction Lien Act. And the fifth topic will be what I call crystal ball gazing, which is essentially looking forward to consider how these amendments are going to impact future conduct and construction work. So first, let's cover a brief history of how we got to where we are now. So by way of background, let's first cover essentially the traditional construction pyramid, because this helps bear in mind how these provisions come into play and how they impact an owner. So in the traditional construction pyramid, you have an owner at the top of the pyramid who retains a general contractor. That general contractor then typically will retain various subcontractors or suppliers directly, but usually it's subcontractors. And then those subcontractors can then in turn retain other subcontractors and material suppliers. Now, in this construction pyramid that we're looking at, it's important to bear in mind that each line between the various boxes represents a contract or a subcontract. Now, the relevance of that is that because in the past, so we're talking pre-1873, subcontractors had no rights to claim against an owner because they had no contract with the owner. So if a subcontractor was unpaid and had a claim, their only claim was against the general contractor. So throughout this presentation, you're going to see short forms. So if you see O, that's going to refer to owner. And if you see GC, that's going to refer to general contractor. So going back to what I was saying, the only claim that the subcontractor would have was against a general contractor. That created risk for the subcontractor because the general contractor may not have much money, and they certainly probably wouldn't have as much money as the owner. So the owner then would benefit from essentially the blood, sweat, and tears of the subcontractor, and but the subcontractor would have no recourse against the owner. So this was, as you can imagine, problematic from the subcontractor's perspective. So in 1973, the Mechanics Lien Act was enacted. And this Mechanics Lien Act created the concept of a mechanics lien. And this gave a claimant, and this could be either a general contractor or a subcontractor, a right to claim an interest in the land of the owner. Now, if we fast forward to the present, currently what we have in place is called the Construction Lien Act, and it came into force in 1983. And the Construction Lien Act set out that a person, so person meaning, a general contractor or a subcontractor or a supplier, or it could be actually an individual if they were an independent contractor. So a person who supplies services or materials, I'm sorry, I went to the wrong slide. Person who supplies services or materials to an improvement has a lien against the interest of the owner in the land. Now, in order to preserve a construction lien, preserve means to register the construction lien against title to the land. That has to be done within 45 days. Now, when I say within 45 days, there is a trigger point for when you start calculating that 45 days. However, it becomes a little complex because it depends on whether it's a subcontractor or a general contractor. So let's just go with within 45 days as a general concept. Then the second step in order to proceed with a construction lien is that the claimant must perfect the lien, which means to start a lawsuit, essentially issue a statement of claim. And that must be done within a total of 90 days or 45 days after the first 45-day period ends. The next step is that the claimant must be ready to set the matter down for trial. So say to file documents with the court to say we're ready to go to trial. And this has to be done within 2 years. So as you can see, this creates a fairly long time period before a subcontractor or a general contractor has an opportunity to get paid, which flies essentially in the face of the purpose of the Construction Lien Act, which is that it's supposed to be of a summary nature. It's supposed to be a quick remedy for trades and contractors and subcontractors. So to remedy that issue, in September 2016, the government released a report on recommended changes to the Construction Lien Act. This led to Bill 142 being introduced in May of 2017. Bill 142 was granted royal assent on December 12, 2017, and this bill amends various statutes, but as well as the Construction Lien Act. One of the amendments that has come into place because of Bill 142 is that the Construction Lien Act is going to be, or will be renamed, the Construction Act. And the reason being that the current Construction Lien Act, although it does deal with more than just construction liens, for the most part, I mean, that's the main focus of the Act. And by renaming it the Construction Act, the intention was to reflect that these amendments now make the Act much more broad, and they don't just deal with liens. It doesn't just deal with liens. The main focus is not necessarily just liens. There are some very significant changes. Now, the current status of the amendments is that there were some housekeeping and non-substantive amendments which came into force, and they are currently in force. We're not going to go over those because they're not very relevant. They're not that significant. The rest of the amendments are the ones we are going to discuss today, and these are the amendments that are much more significant, and one grouping of these amendments takes effect July 1st, 2018. And the most significant changes that will take effect at that time are the amendments to the lien and the holdback rules. Another set of amendments that are very significant and will take effect October 1st, 2019 are the prompt payment and adjudication amendments. There's also significant revisions being made to the regulations, and they are being developed currently. A draft was released February 9th, 2018, but these regulations are still being worked on, and they will set out a lot of the actual details that are required in order to understand how these amendments and provisions will proceed. Now, because the current Construction Lien Act is, for the most part, still in effect, there is some grandfathering that has to be considered. So if a contract has been entered into before October 1st, 2019, then the prompt payment and adjudication amendments will not apply. So the current state of affairs will be what applies if the contract is entered into before October 1st, 2019. The same thing applies with respect to the July 1st, 2018 deadline. If a contract is entered into before that date, then those amendments which take place on July 1st, 2018 will not apply to the contract. The same holds true for the actual procurement process. So if a formal procurement process such as an RFQ or RFP or an RFT, so the RFQ stands for Request for Quotations, RFP stands for Request for Proposals, and RFT, Request for Tenders. So if any of those procurement processes are commenced before the July 1st, 2018 date or the October 1st, 2019 date, then those later amendments will not apply. This is important to bear in mind because some of these amendments, especially the amendments that take place on October 1st, 2019, are very significant. So if an owner wants to sort of beat those amendments, then you want to make sure you enter into a contract before that October 1st date or commence the procurement process so that you don't have to worry about these adjudication and prompt payment amendments. Okay, so let's discuss the prompt payment amendments in more detail. So the main goal of the prompt payment amendments is to impose strict timelines for payments that will be made to general contractors and subcontractors. And again, if you see subs throughout the presentation or the slides, subs stands for subcontractors. Now, in order to do this, the amendments have introduced a new concept called a proper invoice. Now, it's very important to bear in mind that this concept of the proper invoice only applies with respect to general contractors. That could also be construction managers. It means any entity that has a direct contract with the owner only has to worry about this concept of proper invoice. Now, what a proper invoice entails is that it must include the general contractor's name and address, the date and period of supply that they supplied services or materials to the improvement or the project, a clear description of what was supplied, the amounts payable and the payment terms, details of where the payment is to be sent, and any other information which will be required by the regulations, which, as I mentioned earlier, have not yet been finalized. So there could be other information that is required, but that remains to be seen. Now, with respect to this proper invoice, it has to be issued monthly unless the contract provides otherwise. So this means that owners and contractors can negotiate to have a different payment period whereby proper invoices don't have to be issued monthly. But of course, if an owner puts that into a contract, you run the risk that the general contractor may object, and so you may not be able to retain that general contractor if this becomes a sticking point in negotiations. Another important factor to remember is that the issuance of a proper invoice cannot be made conditional on prior certification by a payment certifier or owner's prior approval. Now, the reason I mention this is because once that proper invoice has been issued, it creates some serious obligations for an owner. So an owner may want to try to avoid those obligations by attaching conditions to what constitutes the proper invoice or what creates the trigger point for the owner's obligations. However, under the amendments to the Lien Act, or to the Construction Act, I should say, that is not allowed. So you can't put into your contract that the proper invoice has to be approved in advance by a payment certifier, or by the owner. And one of these serious obligations that I mentioned with respect to a proper invoice is that once the owner receives that proper invoice, they have 28 days to pay that invoice. Now, the owner does have recourse if there are issues with the invoice. So if the owner disputes the entire invoice or portions of the invoice, they can give a notice of non-payment within 14 days of receipt of this proper invoice. Now, this notice of non-payment has to be in a specific form that will be specified by the regulations. It has to specify the amount that the owner is refusing to pay, and it has to describe the reasons for why the owner is refusing to pay either the entire invoice or portions of the invoice. If the owner only identifies certain portions of the invoice in the notice of non-payment, then it must pay all the other portions of the invoice that it has not included in the notice of non-payment. Now, if a GC receives this notice of non-payment from an owner, the GC or general contractor must, within 7 days of receiving that notice, then give to each of its affected subs or suppliers. And I say affected subs or suppliers for a reason that I'll get back to in a moment. They must give each of these suppliers and subcontractors a copy of the owner's notice of non-payment, and they must also prepare their own notice of non-payment, again, which must be in a form prescribed by the regulations. It must specify the amount that isn't going to be paid, and the GC must also undertake to refer this matter, this payment dispute, to adjudication within 21 days. We'll speak about adjudication later in the presentation, but just bear in mind that this notice of non-payment has to advise or indicate that this matter will be going to adjudication. Now, the reason I mentioned the fact that the GC has to give these documents to each affected sub is that if the GC's invoice has broken down the amounts for which it's seeking payment so that it shows, the work for the excavating sub or the electrical sub, then the owner, if it disputes certain aspects of the GC's invoice, so let's say the owner only disputes the work of the electrical subcontractor, then the owner must still pay for the excavation work, and therefore the GC doesn't need to give notice to the excavation subcontractor because it's not affected by the owner's notice of non-payment. Now, if a GC just gives a very general invoice that just has one lump sum and doesn't give an adequate breakdown, then this may not be possible because the owner may have to essentially just object to the entire invoice because it won't know which aspects of the invoice relate to which aspects of the work. So what does this all mean for owners going forward? What this means is that owners must be ready and have their payment certifiers ready to review these proper invoices once they're received, because, and I would say they should be ready to do that within less than 10 days after receipt of the invoice, which is a very short time period. Because if the owner intends to object and deliver a notice of non-payment, there has to be sufficient time to do that by day 14. So really, the payment certifier has to be ready to go, ready to review this invoice, and able to advise the owner whether there are portions of this invoice which are improper, which are excessive, which relate to work that has not yet been completed, various reasons that a payment certifier might refuse payment. They have to be ready and able to respond in a very short time frame. So that, as I mentioned, so the owner can get out the issue of notice of non-payment within the 14-day period so that it's not obligated to pay the entire invoice. But at the same time, the owner should also be ready for adjudication, because once that notice of non-payment is sent out, this matter is going to have to go to adjudication. So there's a lot of additional obligations on the owner that are essential within a very short time period after receiving that proper invoice. If the owner doesn't object to the proper invoice or portions of it, then the other significant change is that the owner must be ready to pay that invoice within 28 days. That's typically shorter than the time period that owners currently pay invoices. Usually, you've got at least 30 days, often more. So there needs to be funding available and ready to be dispersed within a 28-day period. Now, in order to get around this, there is the ability for owners to amend the invoicing provisions in a contract so that the invoices are only to be issued in particular phases or on a milestone basis instead of monthly. But again, you have to insert that into the contract and get the general contractor's agreement to that term. We're now going to discuss the interim adjudication amendments. Now, the goal of these amendments to the Construction Act is to expedite resolution of disputes and to try to minimize disruptions on the project so that the parties stay on the project and keep doing work. Now, in order to have this adjudication process proceed, there is going to be an authorized nominating authority set up. It's essentially going to be like what we currently have, which is ADR chambers, which is a group of mediators or a group of arbitrators. So it's going to be something like that. That's at least what it appears to be. And this authorized nominating authority is going to be responsible for training adjudicators, qualifying adjudicators, maintaining a list of adjudicators, and if the parties can't agree on which adjudicator to use for a dispute, then this authorized nominating authority will also appoint an adjudicator. Now, the types of disputes that will go to adjudication relate to valuation of services or materials provided, payments, including COs or CCOs, which stands for if there's change orders or contemplated change orders. So if a general contractor is seeking extras on a project and the owner disputes that, this could go to adjudication. Disputes arising from notices of non-payment, and if there are set-off claims, and also if there are disputes regarding the payment or non-payment of holdback, and any other matters that the parties agree to send to adjudication or as are set out in the regulations that can go to adjudication. Now, it's important to bear in mind that this adjudication process is still available even if a dispute is going through litigation or going to arbitration. So it's almost like you have a doubling up of the processes to resolve disputes. So that is something to bear in mind, because if you have a dispute from a notice of non-payment, it has to go to adjudication, but you still could litigate it in the courts or take it to an arbitrator. There is some flexibility with respect to the procedure for adjudication, and the parties can set out their own procedure in their contract or in a subcontract, but it has to comply with the Act, so it can't be completely different than what's set out in the Act. If this is not included in a contract or subcontract, then the procedure set out in the Act and the regulations will be what governs this adjudication process. Now, when a matter is headed towards adjudication, the first step is that a notice of adjudication has to be issued. This notice of adjudication has to set out the names and addresses of the parties that will be involved in the the adjudication, a brief description of the dispute, the relief that's being sought in the adjudication, and a name of a proposed adjudicator, bearing in mind that a proposed adjudicator or an adjudicator as agreed upon between the parties cannot be specified in a contract or a subcontract. And as I mentioned earlier, if the parties can't agree on the adjudicator, then the authority will appoint one once it's been requested to do so, and it must appoint one within 7 days of that request being made. So the second step of the adjudication process provides that within 5 days after the adjudicator is appointed, the applicant has to serve the original notice of adjudication, copy of the contract or subcontract, and documents to be relied upon during adjudication. It's important to note that the adjudicator has very broad powers. They can issue directions with respect to the conduct of the adjudication, so there is some flexibility there, and it's at the determination of the adjudicator. The adjudicator can also visit the actual project site and conduct its own inspections. The adjudicator can also seek the assistance of experts, and the adjudicator will have any other powers that will be granted to it under the regulations. Now, the third step of the adjudication process is that the adjudicator is required to make the determination regarding the dispute within 30 days of receiving the documents. Now, this 30-day time period can be extended up to 14 days if the adjudicator requests that it have an extension, or it can be extended upon agreement of the parties for any length of time. Now, the adjudicator's determination is very significant because, first of all, it can be admissible as evidence in a court. It is binding on the parties unless the parties then take this matter to court or to arbitration, which essentially will reverse, or essentially could reverse the adjudicator's determination. The determination can also be filed at court and enforced as a court order. There is a limited ability to appeal an adjudicator's determination. So judicial review can be sought with leave of the court. So you have to get permission of the court to have judicial review of the determination made. And there are very limited scenarios where this will be allowed. And that's where there is the potential to be able to prove that there's been fraud, bias, etc. Other serious criticisms or reasons for asking for this judicial review. Otherwise, that determination is binding and has to be complied with. Now, with respect to the adjudication procedure, of course, we have to consider the costs aspect. So the adjudicator's fees will be shared between the parties equally, subject to section 13.17, which we'll discuss very shortly. Each party to the adjudication has to pay for their own legal costs, again, subject to this section 13.17. Now, section 13.17 is very interesting, and it has some serious implications. What this section says is that if an adjudicator determines that a party has acted in respect of the improvement in a manner, that is frivolous, vexatious, an abusive process, or other than in good faith, the adjudicator may provide that the party be required to pay some or all of the other party's costs, any part of the adjudicator's fee, or both. Now, why this is so significant is that what you'll note is that this section doesn't relate to an abusive process in the actual adjudication process, or which would be analogous to if there's been an abusive process in an actual litigation, or how parties conduct themselves once they've sued each other or engaged in court proceedings. This is in respect of the conduct on the actual project. So this has some very, very serious ramifications because, as I've mentioned, this can impact the portion of the costs and the portion of the adjudicator's fees that have to be paid by a party to the adjudication. So if a party comes to adjudication and they have behaved in a high-handed and unfair manner on the actual project, they can be punished for that by the adjudicator. Now, once an adjudicator issues its determination, if that determination requires one party to pay another party or other parties, then that payment must be made within 10 days after the determination, which is a very short time period. If, let's say, the owner is required to pay but fails to do so within the 10 days after the determination is issued, there are also some serious implications, because this means that the general contractor can stop all work on the project until the owner makes payment of the amount that it's been ordered to pay under the determination, plus interest, plus the general contractor's costs of suspending work. So the demobilization costs that are incurred by the general contractor, meaning to take all its men off site, to take its equipment off site, all those costs also have to be paid by the owner. And the owner must also pay the general contractor's costs when it comes back to the job site. So the remobilization costs, so to bring everyone back to site, to bring all the equipment back to site, those costs must also be incurred. So as you'll note, it's very important that once a determination is issued, it must be paid within that 10-day period, because otherwise the general contractor now has a statutory right to walk off the job. Currently, the way things are is that often general contractors would just walk off the job, but it's not always a good idea for them to do so. So often they would stay on site because they would be worried that they might be deemed to be in breach of contract. So they would stay on site and keep working, and that would keep the project moving forward. However, this amendment now gives that general contractor the statutory right to walk off without penalty, and in fact, it gets rewarded the amounts that are owed to it before it has to come back to the job site. Now, there are some gaps in these amendments, and perhaps they will be addressed in the regulations. But right now, there is some missing information with respect to the adjudication amendments. So, for instance, it's not specified how long the parties have to agree on an adjudicator. As I mentioned earlier, there is a time period within which an adjudicator has to be appointed if one of the parties requests that the adjudicator be appointed, but there's nothing specified about how long they have to try to agree on the adjudicator before making that request. There's also nothing specified about the timing for the delivery of responding materials. There is a time period by which the applicant has to deliver materials, but there's nothing specified about the timing for responding material. There's also nothing specified about whether the hearing can proceed or has to proceed orally or only in writing, or whether those are options. Another aspect that hasn't been addressed yet is whether there will be the ability to question or cross-examine opposing parties, and whether there will also be the right to deliver additional materials beyond just what is already specified. So as I mentioned, this has not yet been dealt with in the draft regulations that have been released, but perhaps it will be. That remains to be seen. But I would pose the question that perhaps these are aspects that can be included in the contract. But again, that remains to be seen. So what does this all mean for owners? It means that owners must have sufficient resources available to them to respond to an adjudication notice. So you must have people available and ready to respond, because there is a very short time period once this whole adjudication process gets underway. And so owners have to be ready, able, and willing to step up and be prepared for this adjudication process. Otherwise, they may receive an unfavorable determination. In order to be ready and able to respond quickly, owners must keep current records about the state of affairs on the project. That's a bit of a challenge, because currently owners rely on the general contractor for the most part to keep an eye on things, or the consultant, or they may have hired an independent project manager to oversee the project on their behalf. But there has to be a definite awareness of what's going on the project, and documentary proof and evidence about what's going on in order to respond when an adjudication commences. Now, another thing to consider is that, will this process create a situation where general contractors and subcontractors may think it's better to just overstate their invoices and then adjudicate, because if they're successful, they've walked away with more money perhaps than what they would normally collect, and maybe they'll have the attitude that there's nothing to lose, why not give it a shot? Now, hopefully they won't do that, because it does take a fair bit of time and energy to proceed with this adjudication process, but this is something that will sort of play out, I guess, once the amendments take effect. It's also, as I mentioned, very important that owners comply with a determination. They don't have the option to not comply, because, as I mentioned, it can be enforceable as a court order, and the general contractor can walk off the project. And owners must also bear in mind Section 13.17 with respect to good faith, and ensure that they are conducting themselves and treating the general contractor in a fair manner on the project. Now, some other amendments that we should consider relate to various provisions of the current Construction Lien Act. So one of those is with respect to lien rights. So the current act, as I mentioned, is 45 days to preserve a lien or register a lien. The new act will make this now a 60-day time period. And bear in mind, this is what comes into effect July 1st, 2018. The current act allows 90 days to perfect the lien or start a lawsuit. The new act will allow a total of 150 days, so 90 days after that first 60-day period expires. There is also the possibility of an extension of the lien period if the lien becomes the subject of adjudication. And this is a very significant amendment because currently there is no way under the Construction Lien Act to amend the time period. If you miss that 45-day period or that 90-day period to perfect, you are out of luck. This possible extension is a big change. Another significant amendment will be with respect to holdback. So, as I'm sure you all know, when a payment is made to a contractor on a project, the owner is required to pay 90% of the invoice and hold back 10% as statutory holdback under the Lien Act. And that has to be maintained until the end of the project and until the expiry of the lien period. Now, the amendments to the Construction Lien Act are going to allow for holdback to be released on an annual basis or in phases if those are identified in the contract. So rather than having to wait till the very end of the project and release all the holdback at once, this can be done in a piecemeal fashion. However, this only applies where the contract price is greater than the amount that's going to be prescribed in the regulations. The current draft regulations specify a $20 million contract amount. And the contract has to provide for this annual or phased release of holdback. The purpose of this is that if you have a very significant project that is going to take several years, your excavators, your foundation subcontractors, the people that do all the work very early on, sometimes have to wait 2-3 years to get their holdback. And that holdback for a smaller company can be a significant portion of money. So this allows them to not have to wait as long to get that holdback money. Another amendment with respect to the payment of holdback is that the owner must pay the holdback when it becomes due, unless within 40 days of publishing a certificate of substantial performance, the owner publishes a notice of non-payment. Now, just to make sure everyone is clear as to what I'm talking about, when you have a big project, when it reaches a certain level of completion, the general contractor, with the approval of the consultant, will publish what's called the Certificate of Substantial Performance in a construction trade newspaper. This signifies to the world that the project has reached a certain level of completion and the lien period is now starting to run. At the end of that lien period, the holdback is then paid out. So with this new amendment, once 40 days or within that 40-day period of that CSP being published, the owner has to publish also a notice of non-payment, again signifying to the world, I'm not going to be paying this holdback, and there for whatever reason the owner has. And they also have to give a notice that they're not going to pay it to the general contractor. The general contractor is then not required to pay holdback to the subs if they give a notice of non-payment and refer the matter to adjudication. But if the general contractor doesn't take that second step or take that step that is their requirement, then they are on the hook to pay the holdback to their subs, regardless of whether they've received it from the owner or not. Some other amendments are that liens can now include any direct costs as a result of delay. Now, the way things currently stand is technically claimants are allowed to claim for delay, but it's not specified in the statute that they can do so. But it's known amongst construction lawyers that as long as you're only liening for hard costs, you can actually lien for delay. But now it's going to be set out expressly in the statute. And these direct costs are also defined in the statute to be the reasonable cost of performing the contract or the subcontract during that delay period, but it can't include indirect damages such as loss of profit, productivity, or opportunity, or any head office overhead cost. So again, it can only be hard costs that have been incurred as a result of the delay. This is very significant for owners as well, because as I said, even though it technically can be done now, a lot of lien claimants don't know this, and so they don't necessarily lien for this. So this could lead to larger liens when you have a project that's delayed. Another amendment is going to be to the substantial performance definition. So under the current Act, substantial performance is achieved, once substantial performance is achieved, then that leads to that publication of the certificate of substantial performance that I mentioned a short while ago. That definition is now going to be changed. Currently it sets out that substantial performance is achieved when the amount of work remaining to be done or deficiencies in the work are less than this number that comes out when you apply this numerical formula. And the numerical formula is that you take 3% of the first $500,000 of the contract price, 2% of the next $500,000 of the contract price, and then 1% of the balance of the contract price. So that means for anything over $1 million, you add on the additional 1% of that contract price. That helps you arrive at a number, and if the amount of outstanding work or deficiencies is less than that number, then substantial performance has been achieved. The certificate can be published, and holdback can be released 45 days, the 46th day after the publication. This new amendment will create a higher number, because the formula now will say that it's 3% of the first 1 million, 2% of the next 1 million, and 1% of the balance of the contract price over 2 million. So this means that parties will be able to attain substantial performance sooner. And that means that holdback will have to be, or can be released sooner as well. Another amendment is with respect to the amount of security that has to get paid into court to remove a lien from title. So the way the law currently stands is that if a lien is registered on title, a party can vacate it, meaning they can take the lien off title and attach it to security paid into court instead of the land. Currently, the amount of money required to do that is the full amount of the lien plus the lesser of $50,000 or 25% of the lien value, and that's in respect of costs. So that full amount has to then get paid into court. So that means that if a lien is more than $200,000, the maximum security for costs is $50,000. So if you have a $200,000 lien, to vacate it, you have to pay $250,000 into court. Now, the new amendment will allow greater security for costs. So the amendment now, or will state that the lesser of $250,000 or 25% of the lien has to be submitted as security for costs in addition to the amount of the lien. So that means that any liens that are greater than $200,000 will be more expensive to vacate or to get bonds to vacate. Now, this is typically the requirement of the contractor. Typically, owners have in their contracts that if a lien appears on title, the contractor is required to take it off title and by posting security. But sometimes the owner may do it for various reasons. So this is important to bear in mind. The current Act has SetOff rights that allow a owner to set off amounts that may be owing to the owner by the contractor for any other project or matter, as long as you've got the same parties involved. The amendment to the Act is now going to limit this right of set-off so that it only applies with respect to claims related to the same improvement. So even if the owner has two projects going on with the same contractor, you can't set off between the different projects. You can only set off if you have a back charge against the owner if it relates to the same improvement. All right, so where does this take us? It's quite apparent that there will be a lot of growing pains with respect to these changes because these are significant. Currently, the CCDC has no plans in place to amend the standard form contracts that are typically used for large projects. So in order to address any of these issues that we've discussed, the owners will have to amend their supplementary conditions in order to make sure that they've covered off issues that they want to address. The process of adjudication raises the question, will parties be sacrificing the correctness of a determination or a decision in the interest of speed? And as I mentioned earlier, parties can also relitigate. So you can litigate at the same time or you can relitigate a determination. But is it realistic that a party will do that? Because, you know, an owner may be ordered to pay some amount of money and they may not like the result and may think that it's not fair or not correct, but the cost of litigating that may make it prohibitive, and they may decide, you know what, it's better to just pay this than to spend the money relitigating it with the uncertainty of the result. So the other potential change we may see is that there could be a lot of adjudications that start to happen because general contractors and subcontractors may feel like they have nothing to lose. But will this have an impact on the project? Meaning, will it make people focus their attentions on other aspects as opposed to the actual work that has to be completed? These are all things that remain to be seen, and we'll just have to wait and see what happens, I guess. So in summary, there are lots of changes. This is a completely new way of doing things. Owners will have to consider new processes to deal with these invoicing issues, the payment within 28 days, the adjudication process. It may require more manpower. It may require that you have a payment certifier available. Well, it will require you have a payment certifier available on very quick notice, or that isn't drawn in a bunch of different directions or working on a bunch of different projects, because they're going to have their attentions focused on the project at hand. And the owner will have to potentially revise their contracts and also make sure that they conduct themselves in a fair manner when the project is underway. So that's those are the topics I wanted to cover. Thank you. I guess we now may have some questions.
So we are open to receiving questions, and I know that we can see a few coming in through the chat box, so we do have a couple of minutes. Cara, are we able to answer one of the questions?
Yes. Okay, so there's a question about the adjudicator fee. Will there be a tariff for the rates or individual rates depending on the adjudicator? That has not been determined yet, but my suspicion is that it will be similar to having roster mediators, where there are limits on the rates that can be charged, but it's not clear yet whether that is in fact the case. Another question on the same topic is, once an adjudicator is selected for one dispute, are they then appointed for future disputes on the same project? Well, if the parties agree, then they can certainly have that same adjudicator resolve future disputes with respect to the same project. And it probably would be a good idea if everyone's happy with the adjudicator and they have knowledge of the project. It might be a good idea because it will be a more efficient process. But again, unfortunately, it remains to be seen whether the authority would appoint the same adjudicator for future disputes if the parties can't agree. Oops. Shoot. I'm sorry, I messed that up. Damn it. Okay.
Okay.
Sorry.
We're just checking for any additional questions coming in. Probably we could take one more if there's any more questions.
Okay, and again, sorry, along the same idea, question about, let's see here.
An owner then should carry contingency.
Yes, okay, so Jill has written, an owner then should carry a contingency in the budget to allow for these additional expenses and also the administrative effort that will be required to manage the process. That's a very good idea because it's most likely that this will add to the costs, and these costs will have to be considered and factored in. As far as getting funding for the projects, I don't know, sorry, the question is, do I see this as being a stumbling block in terms of owners getting funding for the projects? I don't think it will be a stumbling block. I guess it depends on the size of the project. If it's a very large project, then the amount that should probably be set aside to cover these processes and procedures will probably be, small in relation to that. So I don't think it will create a stumbling block. I think it will still be something that will be deemed to be reasonable and required as part of the funding. I don't see any other questions, but I'm not sure.
And that does bring us to time for today. So we do want to sincerely thank Cara for taking the time to talk to us today about this very important topic for all of us that are engaged in this space. Thank you to all of you for attending our session this morning. As always, you know where to find us to send in your questions to Coffee Talk, MT on Call, or to Cara directly on this topic. It will be me that will be joining you next month for our next Coffee Talk session. It has been a time of very active integration activity across the sector. And so we'll be talking specifically about integration and the role of the lead agency, and I look forward to having that dialogue with you in our next session. We do always appreciate your feedback. If you can take a few minutes at the end of the session to fill out the survey form, we would be most appreciative. And if there are topics that are of particular interest to you, please do let us know, and we will do our best to bring content to you that you would like to hear. Thanks, everyone. Have a wonderful day.